Thank you.
And welcome back to the Law&Crime Network. I'm your host, Amy Dash, and I'm joined via Skype by Mark Eiglarsh, who's a former prosecutor, practicing attorney for more than 2 decades over in Miami. Having a bite to eat as we speak. Mark, how's your food?
Oh, are you really putting me on with food in my mouth?
You're chewing. I gave you a warning. I said you got a 10-second warning. You said, then I can't eat. I said, go right ahead. We're not, it's informal.
Go right ahead
this
means
is a casual
we're not gonna
atmosphere.
Wait, first of all, I can't hear you.
Let me ask you something between bites. We were just speaking with an officer who located the body of 8-year-old Cherish Perrywinkle. The story goes that her and her mother and her sister, a poor family, were at the dollar store when a man comes over, pretends to be a good Samaritan, takes advantage of this mother's hopes and dreams, promises to buy her children clothing, says, let's go to the Walmart, my wife will meet you there, she's got a $100 gift card and I want to buy you clothes, and goes there, literally has this woman picking out clothes for her children. She's ecstatic, offers to get her daughter a hamburger, disappears and brutally rapes and murders this poor 8-year-old girl. I mean, this kept me up at night. I was literally crying myself to sleep last night looking at the picture of this beautiful girl. And so he was convicted within 14 minutes. Not surprising. And in fact, they had trouble finding people to sit on this jury because people were so outspoken during the jury selection process about how much they hated this man and how they would immediately send him to the chair to be put to death. So, first of all, is that common in cases involving children, where you literally have such impassioned juries that it's hard to impanel one?
Yes, the answer is yes. That's probably the most difficult part of my job when I have any case involving alleged abuse, anything like that. You've got to spend the time in jury selection, getting rid of those who would feel the way you do, Amy, where you're just so emotionally distraught about the mere allegations that there's just no way to be fair and impartial.
Is there a difference, Mark, would you say, between people who have children and people who don't have children? Or do you find that you can still see that same level of emotion with somebody who's never had their own child?
I'll tell you this, when I'm picking a jury on a case like this, I don't want people who have children. There is a difference in my thought process before I had kids and then after. There are some of these cases that I won't even take, knowing that it could pay for my kids' entire college education, but I just...
Mark, are you there? We're having some technical difficulties. We're going to get Mark back up. Oh, yep, you're here. Yep, let's go back to Mark. So you're saying because you're a parent, sometimes you just couldn't live with yourself if you took a case involving the abuse or killing of a child.
It's very challenging. It's a choice that I have to make of whether I want to use my gifts, my talents, to assist certain people in senses. That doesn't mean that I won't take a case involving challenging facts, but there has to be a reason why I'm doing it.
Yeah, and so a lot of people were wondering, why wouldn't this man plead guilty right off the bat? Why go to trial when the facts are that there's surveillance video of him in the Walmart with the family right before he abducted the little girl. They found him, his pants were wet, his DNA was all over her. She was found in a creek where her body had literally been dragged down to this creek. There was so much evidence against him. He was already a sex offender. Why go to trial?
Picture that scene in Dumb and Dumber. That's what I was thinking when you were saying that. Like, Earth, I'd never go out with you or whatever. And he's like, so you're saying there's a chance, That's what clients hear. There's a chance. You're not saying 100% the jury won't buy what I'm saying. No, but I'll go with 98, 99%. So you're saying there's a chance. That's number one. Clients want to believe that there's a chance. Second thing is, what's the alternative? You're saying, why did he go to trial? Well, what's the alternative? They're not offering him probation. I'm guessing they probably offered him, if they did it all, they might have said, all right, we'll take the death penalty off the table. If they even offered that. Well, he's going, you know what? The chances of me getting the death penalty are probably low anyway, so I'd rather take my chances. And then even if I'm convicted, then I have hope that the case may come back on appeal.
Yeah, my heart is breaking as we're watching the surveillance video of this little girl following this monster to his van. It is so overwhelming. It is so emotionally overwhelming for people. And it's not just me. I mean, on social media, there are people, they do not know this family, do not know this child. but this precious, beautiful child was tortured by this evil monster. So now they're going to the death penalty phase. If they convicted him within 14 minutes, chances are good that they're going to send him to death. I mean, this is obviously an impassioned jury. Do they even go through the analysis of mitigating versus aggravating factors? Because you already have so many aggravating factors in the way that she died. I mean, there's some gruesome testimony that her organs were destroyed, that she was strangled so hard that blood vessels in her face has popped. I mean, she was seriously tortured. This was a heinous and atrocious killing. Plus, you have the aggravating factor that she was a child, that she was a minor. So that's under the Florida laws. He would be sentenced to death.
Yeah. So to answer your question, they better, meaning, should they be even balancing the aggravators versus the mitigators? Yes, that's their job. I don't care how heinous, atrocious, and cruel.
What is a mitigating factor, Mark?
Their job, maybe, is to take the aggravators and then balance those against the mitigators.
There is no mitigating factor. What is the point of doing the test? There is not one mitigating factor.
Says you. I don't know. Did he help an old lady across the street? I have no idea what the guy did.
He's done nothing but destroy lives. He's a monster and an animal.
Yeah, and maybe he is. I don't know. Maybe you're right. But the jurors need to hear from a separate attorney, not the one who handled the guilt phase. That's why there are two attorneys in a death case, so that someone who didn't just argue he's innocent is the one who's arguing you've got to spare his life. So they'll get up there, and if he ever said God bless you to a teacher, if he ever lived a life without crime, they'll highlight those periods of time in his life, and the jurors may choose not to value anything that's being stated, but it's for their job to consider it.
I'm pretty confident he'll be put to death. Which will hopefully bring some comfort, if any, to this family. I mean, let me ask you about what happened with the mom.
30 years, 25 years, maybe?
Let me ask you what happened with the mom. The mom obviously was devastated and heartbroken. We heard the 911 call. She was duped. I mean, this is a poor woman who obviously wanted to get things for her child. She wanted to get them food. She couldn't clothe her children. This monster took advantage of that and promised her things. She fell for it. She had a moment of weakness where she trusted someone and she shouldn't have, and it cost her her child. Shortly after, her other two children are removed from her care. We don't know all of the details because it's a sealed case, but does that happen? Can that happen where a parent is duped by somebody, maybe doesn't act as responsibly as they should, and then for that reason, a grieving mother has her other two children yanked away from her by the Child Protective Services?
It doesn't seem like those are all the facts, Amy. It just doesn't seem right. Yes, they're nuts down here, and there are times where they pull kids away from parents and they shouldn't. Generally, though, there's more to it. If what you're saying are the totality of the facts, then yeah, that's outrageous. If, however, there's more, that wouldn't surprise me.
Yeah, because I'm wondering if they could do it just solely because they felt she was negligent in that moment. And look what happened. She wasn't supervising her child properly. Let her go off with this man. We've got to get the other two kids away. But if you think about it on the flip side, I mean, now those two girls lost their sister and they're taken away from their mother and put into the foster care system potentially. And they ended up being adopted by a relative. But I mean, during that interim, they were put with a stranger, and we don't know what goes on with that. We're about to have another case coming up in a little while in Nevada where a foster mother was abusing the children.
Add that to the horrendous nature and the ripple effect of this, horrible crime. There's nothing good about it.
Yeah. So let me ask you. So the mother is saying, during the time that they took the two kids and they put them into the foster system, they said that the mother had a chance to prove that she was qualified to get them back. She says that she was grieving. Let's say she was grieving. I don't know whether she dabbled in alcohol or drugs, but she did say that she had trouble finding employment. If a mother doesn't have employment, can't support the children, whether or not she's doing other side activities to cope with her grieving, is that justification enough to say, okay, well, your 12 months are up. We're now stripping you of the legal right to your children and shipping them off to Australia to live with your sister who's adopting them. And now all three of your children have been taken away because of this horrible incident.
Look, if we were in court, I'd object to your question as, assume certain facts that may not be in evidence. I don't know if that's real. I mean, clearly that's what you have been led to believe the facts are. If that's the case, then it does seem a little dubious. Why did this occur and why are they doing that? But I don't take the bait. I don't know if those are all the facts. I don't know what's going on with this woman. I don't know what they're alleging, and I'll reserve judgment until I know all of the facts in the case.
Yeah, because maybe she was getting involved in activities that they felt would be harmful to kids, or they wanted the kids to have a more stable environment.
Maybe she's a drug addict. Maybe she, they looked into it and they found something else that we don't know about. That absolutely happens. And conversely, they could say one child was harmed as a result of actions that they deemed to be negligent. So we have an obligation to ensure that we investigate and protect the other two so they don't fall into harm's way.
Yeah, that's what I was wondering, because I was thinking to myself, if they're purely basing it on the fact that she made this horrible mistake and they're going to take the other two kids away, I think she would learn her lesson from that mistake, from having what happened to her child happen, that she lost a child. It's not like she has to have the other two kids taken away unless, like you said, there were other reasons, other things going on, that maybe she got into some things after that happened because she had difficulty coping with it. And those things could have been dangerous to her other children.
You would learn your lesson. I'd learn my lesson. We don't know anything about this woman, and I certainly don't know anything about the investigators involved. But they have some concerns, obviously. We just don't know.
But we do know that it's a lot harder for poor women and poor men and poor families to fight the system when their parental rights are extinguished. We do know that.
100%. We live in a capitalistic society, and that's why some people can afford me and some people can't. Some people can afford the best when it comes to fighting for custody of their children. And yes, money, unfortunately, does play a role in the outcome that people get sometimes.
Okay, and now we are waiting for a verdict, you're aware of this, Mark, in the case of Bob Ward, who is accused of killing his wife. He says it was an accident. We're going to listen to the 911 tape in a moment. What do you think is the most compelling piece of evidence against him?
That 911 call, which I listened to earlier and then looked and saw who his lawyers were, and one of them I didn't even realize was the guy that I shared space with for many years on South Beach.
Oh, no
I didn't
kidding.
know Sean Ellsworth was, number one, his appellate lawyer, did a great job in getting him a new trial, and who's sitting there with him in court on the case. So good luck, Sean. I think the 911 call, he sounds so damn cold. And yes, as a defense lawyer, I would argue, well, don't judge him. You don't know what he's normally like. But it just sounds so damn bad. It just doesn't sound like someone who would have the effect that you would expect to have when advocating what he's claiming occurred.
But what physical evidence is there that this wasn't an accident, if you think about it, besides the medical examiner testifying that the shooting had to have taken place about 18 inches away from his wife?
To me, what jumps out, and I know they prevented this testimony from being presented to the jury, but I think that jurors kind of know this, and that is women generally don't commit suicide by shooting themselves in the face.
Sometimes, is that even possible? I mean,
anything's possible.
I mean, you can put the gun in your mouth, but from where she was, I guess you could shoot like that. I don't know. It seems like an illogical way to do things.
Had the judge allowed that testimony in, there would be an expert to say that is just not typical, that they almost never find examples where a woman shoots herself in the face, and that's more consistent with murder, which coincidentally is what the first jury found.
What do you think about the motive here, about how she was going to testify in a lawsuit involving him defrauding clients 3 days after she was killed? There was a broken glass, there was wine spilt all over the patio. It seemed like there was things were boiling. They called it like a pressure cooker situation. Things had reached a point where finally there was this explosion.
Oh, if I'm a prosecutor, I like the motive. I love it when people say, "Well, we don't even have to prove motive." Yeah, but every juror wants to know why, especially in a case like this where they're arguing it was an accident. And if there's no motive, let's say, then it's more consistent with it being an accident, or it adds strength to the defense's argument. But you do have a motive, and you have a pretty damn good one. And I think that hurts them.
Okay, so let's listen to the 911 call and then we'll come back and discuss it for a few minutes.
Okay.
What's the emergency?
I just saw my wife.
You just what?
I just saw my wife.
Where's your wife?
She's right here on the floor. Please send somebody at 5277 Isleworth Country Club Drive.
5277 what drive?
Isleworth Country Club Drive.
Okay, I just need to giving me is not coming up.
5277 Isleworth Country Club Drive.
Firework?
Yes, Isleworth. ISLEWRTH.
Okay, what's going on there?
I just shot my wife.
You just shot your wife?
I shot my wife. Yes, please send somebody over.
Stay on line with me. Let me ask the fire department. Don't hang up.
I will.
Where's the weapon at, sir? Orange County Fire Rescue. The address of your emergency? 44.
5277 Isleworth Country Club Drive. Hello?
I'm here. Hold on just a moment.
Oh, I don't know why. I'm sorry.
That's all right. It's 1256.
No, it's 52. Yeah, 77 Isleworth Country Club Drive.
I'm there.
I just shot my wife.
Okay, where's the weapon?
It's in the,
Yes.
I'm sorry.
Where is she breathing?
No, she's dead.
You know that for sure.
I think so, yes.
Okay, sir, where is the weapon?
It's in the nightstand next to the master bedroom. And I'll be glad to meet the officer that's on for.
Where is your wife, sir?
She's on the floor in the master bedroom.
How old is she?
She is 1954. What is it? More than 1954.
Okay, you're sure she's not breathing or?
She's dead. She's done. I'm sorry.
Okay. Sheriff's office, you're on the way? Yes, we are.
Thank you.
Okay, sir.
I'll be in the front door. It's fine. There's no weapon. I'm fine.
Okay, so we're on our way.
Thank you so much.
Sir, you need to stand up for me, but I just start having a clip, so hang on. Please.
I'm sorry, say again?
Sir, did you purposely do this?
No,
Or was it an accident?
it was an accident.
Stay on the phone with me. Do not hang up.
I won't. Thank you.
Yes, sir. I'm here. And the gun is secure, sir?
I'm sorry, say again?
You do have the gun secure, correct?
Yeah, it's next to that in the nightstand. The gun is secured, yes. It's not a problem. No, she would show up. I'll be sitting on the front step.
How long ago did this happen, sir?
I'll be 5 minutes ago. From the front steps.
You're out on the front steps?
Yeah, I'm on the front steps.
Okay.
And they go to the front gate, come to the front steps, and we go upstairs and find Diane. There.
Yes, how old is your wife?
1954, so let's see, whatever that is now. She's fine.
Is that the only weapon in the home, sir? Sir?
Yes, yes, I think it is. There may be one more weapon that's downstairs. I'm not certain.
Okay. What, the gun just went off, or what happened? What exactly happened?
The gun just went off.
Where was she shot at? Where's the wound?
I don't know where it is.
Okay.
This is awful. You see it on the floor. I don't know how it happened.
Where is she at in the house?
Again,
Where is she at in the house?
she's in the master bedroom upstairs.
She is in the master bedroom also?
Yes. No, I'm downstairs.
No, she's in the master bedroom.
Yeah, she is.
Okay.
Yeah.
Yeah, I'm here. Stay on the phone with me, okay?
No, I'm fine. It's fine now. I think it's first.
So what?
I think I was fine on you.
Okay.
Yeah, it's fine. I'm here at 2020 and I think, yeah, they've done past me. Yeah, they're maybe acting. Tell me about that.
Did you see the deputy?
Yeah, I see lights, but then tell me about that. I've been back up.
Okay. Can you step down and wave?
Well, I'll try to wait. Yeah, you must back up. No, okay. You're there.
Yeah, I'm here.
Hey, guys, over here. Over here. Yeah, go ahead and sleep.
Are you still on the front step?
No, I'm walking towards the street.
Where are you walking towards?
Toward the street because they're... Hi, I'm here. Here, hey, on the phone. I'll make the hot stuff.
Okay, sir?
I'm here, guys. No, I got a little phone. We're good.
Are you with the deputy? We can hang up. We're with you.
Okay. Okay.
No further questions, Your Honor.
Welcome back to the Law&Crime Network. You were just listening to the 911 call by Bob Ward to the authorities after he shot his wife, Diane. I'm joined by Mark Eiglarsh, who is a former prosecutor and practicing attorney for more than 2 decades. He's in Miami. Mark, you were telling me that you used to share workspace with the attorney that's representing Bob Ward. Did he have a certain pattern to trying these types of cases that you can clue us into? What was his typical strategy in a case like this?
Gosh, back then, which would have been probably about 10 years ago, we shared space on South Beach. He's a very bright attorney. There's no surprise that he was successful in the appellate work that he did. So he's the one who won the new trial. So I'm always impressed by that. It's, the appellate court is generally not in the business of reversing murder convictions. So clearly he had, an opportunity to find something that went wrong and exploited it and prevailed. So good for him.
Exactly what he exploited is that there were references made in the first trial to this man's right to remain silent, meaning that it was inferred that since he didn't say anything that may have been incriminating and should be used against him, and there was no objection to about 25 references where he invoked his right to remain silent. So that was brought up. But
pretty
what
bad. That would be ineffective assistance of counsel, in my opinion.
Yeah, it was, but the lawyer was dead.
Passionate, intelligent attorney, and I would say that he's pulled off some victories before. We'll see if he's got what it takes in this one.
So then explain to me, why wouldn't he, and maybe he did, encourage his client to take a plea deal? He was basically offered time
You
served.
froze, so I can't.
I'm sorry?
You there?
Yes, I'm here. Did we lose
I
Mark?
didn't hear you. Amy, I'm sorry, you froze.
Oh. You
Try it
see me
again.
now?
Amy?
Yeah, can you see me now?
I can see you, I can hear you.
Okay,
So
great,
can you
perfect. So-
repeat what you said last?
Yeah, I'll repeat the question. I'm wondering why the defense attorney wouldn't have his client, and like I said, maybe he did suggest this, but why the client wouldn't take a plea deal when he was basically offered time served plus a couple of years, and we saw that he was convicted back in 2011.
Right. I didn't know about that plea offer. Let's assume that that's accurate. Yeah, it sounds pretty damn good to me. Unless, the lawyers came in and made him feel extremely confident about his chances of prevailing, and he doesn't want to go back in. That's the toughest thing. Once clients are out, the minute I heard he got bond, it's tough to go back in, So that's probably what he's thinking. I don't want to go back in.
Yeah.
Apparently his health is not great. And however many extra years you're claiming he's got to do to complete the plea bargain, he may not make it. So his thought is it's going to be like a death sentence if I have to go back into prison.
Yeah, but by the same token, Mark, he was facing 30 years on the first go around versus
Correct.
a couple of years.
But now he's got a chance of being acquitted. Maybe he feels that he's got a good chance. Maybe the attorneys that he's assembled, maybe he's learned from the first case. Maybe certain witnesses are not available. Maybe they've done things differently. Maybe, obviously, he feels confident to turn down that deal.
How important was the fact that the daughter testified about the mother's drug use and medications, that she was an anxious, depressed person? Is that at all relevant to the theory that she was trying to kill herself?
Colossal. Not for the reason that you might think. When I heard that, she could say whatever. Yes, and it has relevance, and it's obvious that she's got this history, but that's not, to me, what is as loud as something else that I'm hearing. What I'm hearing is, I believe in my father. I am supporting him. I believe that you should find him not guilty. I think that what he's alleging is true. She's not saying all that, but she's saying all that without saying it.
Yeah, it's implied. So we heard on the 911 call that basically he said that he shot his wife. The 911 operator said, was it an accident? He said, yeah, it was an accident. The fact that he said that, despite his lack of emotion throughout the call, will that help the defense's theory?
Absolutely. Until I heard him say that, I was like, this guy's screwed. Why is he going to trial? When I heard that, I was like, okay, I hate the effect. I would tell my client, you sound horrible. Because I don't think that there's any reasonable juror who would sound the way he sounds when you call in something that was a tragic accident and you just had a struggle over a gun. He sounds like he killed someone in cold blood. Now,
yeah, he does.
when he says it's an accident, he preserves his right to reasonably argue later on, okay, it was an accident.
Even though the 911 operator basically fed him the answer, was it an accident? He goes, oh yeah, it was an accident. Almost like, yeah, that sounds like a good excuse. I'll take it.
I'm with you. That 911 operator is no Perry Mason, and there was the golden opportunity to cross-examine him and lock him into a story to help his defense or to obliterate it. And I don't think she did a very good job.
Well, I said last time I was on hosting and I was talking to Bob Bianchi, I said, why aren't these 911 operators trained to not only gather information, but if there is time and the emergency response is on the way, to gather specific information and probe as to what unfolded, because that's the time when, if the person's in shock and disbelief, or if they're anxious over what just happened, they may not have the inhibition to keep all the details in.
They may be trained to do that, but it's an art form. What you're really doing is you're cross-examining someone because she was trying to get out information, and you can see that he wasn't as forthcoming as we would have liked, and that was either intentional or it just wasn't working. He wasn't hearing her, but I don't know. I mean, she tried, but she just wasn't effective. I think it might be, look, you can't expect them to be a jack of all trades. They're not litigators. They're not, let's go through every detail bit by bit so we can lock you in. I think that requires more than the training that they're given.
As damaging as you think that the 911 call is, when he's in court listening to it, are the jurors watching how he's reacting then as well?
That's an excellent point. It's theater. I tell my clients, trials, they're certainly not about seeking the truth. We always say the truth's going to come out. That's crap. Prosecutors have an obligation to seek the truth. The defense lawyers do not. We don't, period. I'll say it. That's what this is about. It's about seeking the truth. But that's not my obligation. And don't ever think for a second that's what trials are about. So, this concept of, this is about justice. I don't buy that.
Here, when he's sitting there, though, he looks just as unemotional as when he made the call. So
Right,
when
that's
did
good.
his defense
That's good.
attorney
Yeah.
tell him, if we want to make out this excuse that you were totally numb and in shock when you made that 911 call, let's counteract it with a little emotion while you listen to it, to show that you are devastated over losing your wife. But it still looks like he doesn't give two shits.
Right.
Pardon my
Now
French.
that being said, I'd point to him in court and say, look, this is how he is. Everybody's different. This guy just has this effect. But again, going back to what we were talking about earlier, it is theater, and I can't control what a jury does. I can control almost everything else. So I can put a pen in my client's hand. I can look at his reaction when certain pieces of evidence are being heard and make sure that it is the right effect. It's what I want him to be, how I want him to be behaving. I can't force him to do it, but I can point out, like, stop smiling.
Right.
Or put your head down and write.
Right.
Those things are choreographed to some extent if you have a very good defense lawyer.
Yeah, and so the bottom line is that with this tape, he made the call, right? And so you have that evidence where he says, I shot my wife. But besides the tape, do you think that the prosecutors had enough to prove beyond a reasonable doubt that this was not an accident? Because the truth of the matter is, we don't really know what happened in that house.
Okay, so here's the answer, all right? The direct answer is I don't know. I'm done, saying jurors got it wrong or right. I don't know that I ever said that, but I would think that.
You just said it.
The reality is, Amy, we're not in the courtroom. So that's the first thing. We're reading accounts about what we think the evidence is, and even if we're watching it on the screen, it's not the same as being there. So a certain deference, in my opinion, is always given to jurors. That's number one. Number two, not one single piece of evidence equals murder, the argument is. It's kind of like bloodshot eyes don't equal DUI. Slurred speech doesn't equal DUI. It's putting every single piece of the puzzle together equals only one thing. Drunk driving, he was impaired. And in this case, to complete the metaphor, if having that motive, that's not, that doesn't equal murder. But you piece together every single thing, I can certainly see why a jury found him guilty in the first trial.
Do you think the fact that he made the call, reported the incident right after it happened, and was so willing to turn himself in helps him or hurts him?
My first impression was, this is a guy who's defeated, who knows he did wrong. He screwed up. I shot my wife. Those wouldn't be my words.
So you viewed it as him trying to take responsibility in that moment, and then maybe later on he rethinks it and says, shoot, I'm going to try to get away with this.
That's kind of how I look at it. And I think from the way you're asking the question, that might be how you're looking at it. And again, I'd love to know what your viewers think. When you hear him say,
it could be played the other way, right, Mark? It could be played the other way by the defense attorney. That because it was an accident, he had no reason not to turn himself in.
Absolutely. Again, not one thing equals the smoking gun. He definitely must be guilty. People can look at this 911 tape in two different ways, and that's what the defense is hoping, that there's two different ways that they can look at it.
Yeah. Okay, so we're going to listen really quick to some testimony from one of the officers, one of the first officers to respond to the scene after that 911 call was placed.
And I'm currently a corporal with the Orange County Sheriff's Office.
Now, back in 2009, were you also employed with the Orange County Sheriff's Office?
Yes.
All right. And how long had you been employed with the Orange County Sheriff's Office?
In 2000, I started in December of 2006, so it would have been about 3 years.
Now, during that time, on September 21st of 2009, what area of patrol were you assigned to?
I was assigned to what's called our Sector 3, which is the Pine Hills area of Orlando. They break it up into sectors. It's just a geographic area to spread manpower.
Now, on September 21st, 2009, did you respond to a call for service around 7:45 that evening?
Yes.
All right. And where was that call for service?
It was in the Islesworth subdivision off of Conroy Road.
All right. Now, I'm going to go out on a limb. Islesworth is probably not in Pine Hills. How come you responded to that location?
I was actually on dinner break at the time. I was eating at a Jersey Mike's down the street on Conroy Road. And like I said, we were on break, but the call came out, and due to the nature of the call and our proximity to it, myself and the other people I was eating with decided to respond.
All right. And who were you eating with?
Deputy Corey Legg, Deputy Ray Bagley. I believe that's it.
All right. Now, were you in standard Orange County Sheriff's uniform?
Yes, sir. I was dressed in uniform.
All right. Similar to what the court deputies are wearing here today?
Yes, sir.
And driving a patrol car?
Yes, sir. Marked patrol car.
All right. So marked patrol car, lights, agency insignia on it and everything?
Yes, sir.
Now, when you respond to a call like this, what type of call did you receive, actually?
It was a call. So we get it through our dispatch. It comes over our radio. And it was an aggravated battery via gunshot. And we got information that the person calling it in had said he had shot his wife. So it's a code 3 call. It's just it's a call we can turn our lights and sirens on. We can, safely disobey traffic laws, all that stuff. So it would be a call that we would respond to in emergency mode.
All right. And did all 3 of you respond to the Islesworth community?
Yes, sir.
And when you got to the Islesworth community, did you have any issues coming through the gate?
No, sir. We told the guard gate that we were there for an emergency call, and they let us in.
Now, when you came through the gate, did you have any difficulties locating the property?
Because I worked in Pine Hills, I wasn't overly familiar with Windermere or Islesworth, so I was trying to pull it up on a map. Deputy Legg was more familiar with it, so at one point he had went around me and drove down the main road, and I followed behind him as we attempted to locate the address.
Did you guys end up overshooting the target location?
By a little bit, not by much.
All right. Now, that call for service that you get out that allows you to kind of code 3, kind of disobey the traffic laws, all the fun stuff of being a cop, does that cause you some concern when you actually have to arrive on a scene like that?
Yes, because when you're going to a call that's in progress, which is usually what happens when it's a violent felony or any type of in-progress crime, the lights and sirens could alert the suspect to your arrival and could make it a safety issue for you once you do show up.
Now, when you exit your patrol car, do you take out your agency-issued firearm?
Yeah, once we determined we were at the correct location, we actually saw an individual standing near the driveway. We got out, and because of the nature of the call, it was a shooting, and the suspect was supposedly calling it in. We did take out our firearms, and we took a position of cover so that if we were shot at, we would be able to return fire and do what we needed to do from a safe location.
Now, did you issue commands to the individual that was at the end of his driveway?
Yes. So I saw a white male standing near the end of his driveway. He had 2 things in his hand. One looked like a phone. It was lit up to his head. I couldn't tell what the other object was. So from where I was standing, I started to yell at him to get down on the ground, drop what he had on his hand, and to listen to our commands.
Did he have some difficulty complying with you at first?
Yeah, initially I would tell him to turn away from us, and he would face us. And then I would tell him to lay down on the ground, and he would do it. And I would say, put your hands behind your back. He would stand up and walk back towards the house. It's almost like he was doing the opposite of what I was saying. He wasn't being aggressive or verbally. He wasn't being rude, or he was being compliant, but he was just having difficulty following my instructions.
Now, was anyone shouting different instructions than what you were issuing?
Deputy Legg was near me behind the tree. We were probably both yelling things in the heat of the moment, trying to get the situation under control. But nobody would have been yelling the opposite. And for the most part, I remember being the main person yelling.
Now, were you the one that actually approached the defendant?
Yeah, once we were able to get the items out of his hand and we determined that we could see his hands, Deputy Legg covered me, and I went in and got him on the ground and ended up securing him in handcuffs.
Now, the person that you handcuffed, do you see him in the courtroom here today?
Yes, I do.
He's doing the courtesy of standing up for you. Is that the individual who stood up? Is that the person
Yes.
that you handcuffed at the end of the driveway in Ellsworth?
Yes, sir.
All right, and that's located here in Orange County, Florida?
Yes, sir.
Now, when you were handcuffing him and taking him into custody, could you smell the impurities of alcohol?
Yes, I did.
And what about his eyes? Did you have an opportunity to look at his eyes?
His eyes were glassy. I did have a very, very brief conversation with him after I handcuffed him. Some of his words were a little bit slurred, but his eyes were glassy and he smelled like alcohol.
Now, when you have him secured, what do you do with him?
At that point, I need to get him away from the front of the house. We're still investigating the shooting crime. And obviously his safety, our safety, we need to move him away from the front of the house. So at that time, we're also trying to find any potential victims or additional suspects. So in the interest of safety, I asked him, is anybody else in the house? He answered that his wife was in the house. I asked, where's your wife? And he said, she's dead. I said, okay, but where is she? And he said, up in the master bedroom. So as I continued to move him away, it was just gathering facts so that I could relay it to additional responding deputies so that we could be as safe as possible and keep the community safe as well.
All right, now, was this a normal-sized house?
No, sir.
All right, how would you describe this house?
It was a very large house. It had, it was probably almost 8,000 square feet. It had like a separate walkover to like a different part of the house with more rooms. It's a very, very large house.
All right, and with it being such a large house, does it take more deputies than normal to conduct what's known as a protective sweep of the residence?
Yes, sir.
All right, and were you able to eventually do a protective sweep of the residence?
Yeah, once we got enough deputies that we felt we could safely do the protective sweep, we did conduct it.
Now, did you have an opportunity to see the victim in this case?
Yes.
All right. Can you tell the jury where you located her?
She was upstairs. You kind of had to walk up the stairs and around to, I guess, what would be the master bedroom. From the master bedroom door, you could partially see her body. It was sticking out from behind like an architectural wall that curved around. She was laying on her left side, and her left arm was out, and the back of her head was kind of facing the entry to the master, if that makes sense.
Was it obvious to you that she was deceased?
Yeah, as we got closer, she didn't respond to any commands, and we could tell she was deceased.
Now, did you touch her at all?
I did not.
Did any other deputies touch her at all?
I don't know.
Now, when you leave that bedroom, did you go outside on the back patio?
Eventually, yes, we made our way to the back patio.
Just a moment. All right, just a moment. Your Honor, permission.
Welcome back to the Law and Crime Network. I'm your host, Amy Dash. We are awaiting a verdict in the Bob Ward case. He was a man accused of shooting and killing his wife. He claims it was an accident. I was just discussing the case with attorney Mark Eiglarsh, who is out of Florida. Mark, I want to switch gears for a second and just ask you about this horrific shooting that took place in Florida, the state where you are. Do you know anything about what went down? You said that you had some sort of a family connection to the school.
Yeah, I'm still heartbroken. We're dealing with the ripple effects of it. My kids know a lot of the kids involved. We live probably 15 minutes from the school.
Wow.
And I'm going to be going on air soon with someone who was a neighbor of the shooter. And he's been giving me a lot of insight as to what was going on with this kid.
The neighbor, because we saw some
Yeah.
of the disturbing things that were on his Instagram account. It's got guns all over it. He's wearing bandanas over his face, threatening messages about killing people, saying, there was one picture of target practice, said group therapy, it works, a lot of cursing. And some of the kids said that they would always joke if there was someone who was going to shoot up the school, it would be that teenager who we know was expelled for disciplinary reasons related to threats and talking about guns and things like that, and then he was going to use them on the students. It's disturbing that he was expelled from the school, yet this could still happen.
Well, he was, yeah, the answer is yes. You're going to hear a lot of troubling things. I'd like to let the neighbor describe those things on his own, but one thing, as you can imagine, and he confirmed, that this kid who was autistic was bullied since he was very little. And just before anyone's rolling their eyes and suggesting I'm making excuses or justifying it, I'm not. But our goal is to figure out what was present. And I think that when you mix three things, mental illness, bullying, and access to weapons, that's not a good recipe.
So what did the neighbor tell you that we don't already know about the inner workings of the shooter?
He told me some things, and I'm going to let him speak for himself. He wants to do that. But just that one thing for sure is extensive bullying since he was young, the autism, and that's it for now.
Mm-hmm. The FBI and the teachers were warned about the suspect here, Nicholas Cruz. Is this a major failure on the part of the government to not investigate? Or as an attorney, do you think there simply wasn't enough evidence that sometimes you just can't do anything until there is a horrific crime like this? Is there any way to get preemptive and proactive about it?
Well, that's what the lawmakers who are pounding their chest would have you believe, that it's preventable. I'm not sure that's the case in our current climate. Significant changes need to be made, and quite frankly, I wonder if the genie's already out of the bottle as it relates to guns and some other things. I don't know. I mean, we have wide latitude to say things that the First Amendment protects, and unless somebody's a danger to themselves and others, and it's clear, I don't know.
He's going to be charged with 17 counts of premeditated murder. You said that some of your children know some of the kids at the high school. Did your children go to that high school?
They don't. No. They go to a nearby school, and we have plenty of friends who go to that school. In fact, we were checking in with them throughout the day because we were very concerned. He'll be tried in Broward County, which is, the courthouse is 5 minutes from my house. So.
Would you ever defend someone like this?
Would I what?
Would you ever defend Nicholas Cruz?
I wouldn't rule it out.
Explain that to people.
Because of the abhorrent nature of the crime, I wouldn't rule it out. I'd need to know more. I'd need a reason to defend him, and I would just I would go visit him. I would talk to him, see what's going on, and decide whether it's somebody that I want to commit to.
Flesh that out a little bit for people who can't wrap their heads around how anybody would want to defend somebody who just killed 17 innocent people, including high school students.
I'll answer it in a way that they'll then understand. Let's do it from a conservative point of view. Where do you want him to go? Prison the rest of his life at a minimum, and maybe some of you want him to die. That can't happen without this little thing we call due process. Due process ensures that somebody is properly represented by competent counsel. That means someone has to be by his side. having been that person who has been by the side of some people who have done some abhorrent things, I can tell you, it doesn't mean that the attorney agrees with what they did, believes in the person themselves. It doesn't mean all the things that the public seems to turn it into. It means that the attorney is doing his or her job to provide good and competent counsel, and only because they're doing that can you get to a resolution like a guilty verdict or an acquittal, but likely in this case, a guilty verdict.
The way you so judiciously frame it, it sounds like you're, as the defense attorney, helping to facilitate the resolution that you think people want to see, which is either life in prison or the death penalty. But in fact, isn't there more to it where you're actually advocating for the person to get off?
Let me make that clear. I started that monologue with, I'm going to say this in the most conservative way possible so that people can go, okay, I'm going to look at the defense attorney a little differently. Because if I, conservative Joe, public, want to see that guy in prison or dead, then there has to be a lawyer by his side. Now let's talk Mark Eiglarsh, person who believes in due process. Yes, a defense lawyer should be by that person's side to do everything he or her can to zealously defend him or her and get the best possible outcome under challenging circumstances.
Yeah, but then, it's the same thing as when people think about how this kid brutally murdered 17 innocent people and then was
Right.
taken to the hospital to be treated for his injuries, to be taken care of by people.
Right.
Make sure that his little minor injuries didn't hurt him too much, that they put a little Band-Aid on that for him. And then you're like the same type of person, because then he gets treated for his injuries, then he goes off to one of the high-powered defense attorneys who advocates for his innocence. A lot of people have a hard time wrapping their head around the fact that that is justice for these families. In the face of so much overwhelming evidence, why do we even need to go through the tedious process of establishing everything that happened? Why do we need to put the parents who are grieving on the stand? Why do we need to put the high school students through the repeat trauma of explaining everything that they just went through?
Funny, I think I heard that same monologue spoken by a number of people, including Nancy Grace, concerning, let's say, like the Duke lacrosse players, right?
I don't know whether to take that as a compliment or an insult.
Well, just think about it. The list goes on and on. Who says the evidence is overwhelming? And if it is, in this particular case, it seems like it is, then it won't be a problem for prosecutors to be able to prove it.
Well, because they all saw him. They all saw him shooting up the school.
You're right. And how do we know that? We know that because these people are going to take the witness stand, raise their right hand, swear to tell the truth, and they're going to point their finger at that guy and say, that's the guy who did it. That's the process that every defendant must undergo so that we can have our rights protected if, God forbid, we're ever accused of a traffic ticket or worse, something as heinous as murder.
Yeah. And so with the 17 counts of murder, just explain how that trial will go, because it's obviously going to be expensive and it's going to be emotionally draining for all involved. Will they have to prove murder for each of the 17 counts? And will it be tried separately, do you think, or together?
All counts will be tried together, but every charge that any prosecutor in this case or any case, every element of that charge must be proven beyond and to the exclusion of every reasonable doubt. So yes, in each single charge, there's a victim behind that charge. They'll need to prove that that person died, and it's as a result of the actions of that defendant, and all the elements must be proven.
You mentioned autism, you mentioned mental illness. Obviously, these things have to be established. You can't just make these claims if they weren't diagnosed by physicians. Right? But what, if you were representing him, what is your defense? Are you going the insanity route?
Well, of course. I mean, that's it. It's
but
not
there's
a
no there's no
it's
culpability
why.
with insanity. There is no culpability whatsoever. Even if he was insane, how does the system expect a jury to find him insane when the repercussion is nothing?
Okay. First, it's not nothing. They go to a hospital and then...
And they're out in 2 months.
Maybe. But to answer your question, it doesn't typically work in general. The insanity defense works in a fraction of 1% of the cases, number one. Number two, it likely will not work in this case. If you believe half of the facts, there's enough there for jurors to hang their hat on that mental illness aside, he knew right from wrong. In other words, mental illness doesn't, it doesn't carry the day. It just gets you into the game. It's mental illness plus, as a result of the mental illness, he didn't know right from wrong. If, let's assume for a second, he did hit the fire alarm because he knew then that would cause the kids to leave the classroom to enable him to then have better access to shooting them, that could be game, set, and match right then and there. That shows, again, he's conscious. He knows what he's doing. It's all it takes. It's a very low burden.
Right, but then it's obviously going to be counteracted with some things that maybe he scribbled in a diary or things that he posted on social media that seem like ramblings that don't make sense.
True, but as you alluded to earlier, and I will agree with you, the chances of him being acquitted or found not guilty by reason of insanity, the chances are so low, so remote, they approach almost no real value.
Because it's a mass shooting, do you think what is the percentage chance you think that he's going to be put to death?
I think it's a low chance.
Why
I think
low?
that because of his age, because of his lack of priors, I think that he's looking at a life sentence. I don't know that they're going to seek the death penalty.
And would you try to make the claim that he's incompetent to even stand trial in the first place? And if so, how would you go about trying to establish that?
Well, there are two different issues. I'm glad you brought that up. There's always two issues when you're dealing with mental illness. One is the person competent now? In other words, a separate issue is whether he was mentally impaired at the time of the shooting.
Right.
The issue right now is, can he assist his defense attorney? Does he know who that person wearing the black polyester is, who's elevated, who's in front of the flags in the courtroom? Does he know what his role is? Does he know who the prosecutor is and what their role is? Does he know where he's located? It's a low burden. I've had some really, for lack of a better phrase, nutty clients who have been found to be competent. And so then I'm dealing with just a complete mental mess and going to trial with someone like that in that condition. But it's a very low burden. The second issue is whether they were suffering from a mental illness at the time of the incident, and did that cause them not to know right from wrong?
And we know that the laws are different in every state, so sometimes it's not just did they have the ability to tell right from wrong, but for example, in the Colorado movie theater shooting case, it was also, did he have the ability to suppress the impulse to kill? That was an additional factor.
Okay, I don't know that we have that same language, but it
seems totally. I know you're not familiar with it.
It's just what's that?
I know you're not familiar with that that legal test in that case, but that seems counterintuitive to me. So in that case with the mass shooting in the Colorado movie theater, James Holmes, the jury had to decide, could he tell the difference between right and wrong, but also if he had an impulse to kill, could he control it? And if he couldn't control that impulse, well, then they're supposed to find that he's not guilty and release him so that he can go out there and kill again if the impulse comes up again? That makes no sense to me.
I remember from covering that case, now I'm remembering, their law is different than Florida. Even the burden of proof is different over there. So it's going to be very different. It is easier for a defendant in Colorado than it's going to be for this guy.
Yeah.
And the short version of our statute, again, I'm paraphrasing, but first, I don't think he'll have difficulty proving that he did suffer from a mental illness, but where he'll find challenges is proving that then prevented him from knowing right from wrong legally. And, it's very difficult, almost impossible to win a case like this.
Yeah. One more question. And by the way, just to go to our other point about him being competent to stand trial, I assume very shortly he'll be going through psychological evaluations that his attorney will try to use to support his inability to stand trial.
Yes, that's one way to look at it. The other way to look at it is his defense lawyer has an obligation to ensure that every stage of the criminal proceeding, his client is competent. And so at a minimum, to effectively represent him, he needs to make sure that he's evaluated.
Yeah. So last question. We saw that there were a lot of social media pictures and videos, which are quite horrifying because what they do is they capture the fear of the students as they are listening to the gunshots and as they are waiting for police. And even in one of the videos, which brought me to tears, the relief when they see the SWAT team come in and the students realize that they're safe after about an hour of living in fear that their lives could be taken at any moment and watching other people get killed in front of them. Now, I didn't see any videos so far that showed the shooter, but will those other videos and pictures be used as evidence? And if so, in what context and to prove what if they don't show the actual shooter?
Okay, the answer is maybe. It depends what prosecutors have available to them, and what purpose. I think they're going to try to get that in because again, we just talked about it earlier. Trials are theater, and theater is about moving the participants, and those videos are very moving. And let me just add too, this fear, and I don't know if it's everywhere, but I think it's hitting us closer to home because we're in South Florida. But my kids all came home. I have 3 kids, 16, 14, and 11, but especially my 11-year-old. He was consumed with fear because this hit way too close to home. Yeah. And then that fear I felt in the courthouse this morning when all of a sudden the alarm went off in Miami courthouse, and you hear Code Brown, and everybody's running around and they're yelling, get out of the building, get out of the building, and no one knows what a Code Brown is. I thought it was somebody failed to flush the toilet. I don't know what that was, but people were running out, and it turns out someone brought in ammunition into the courthouse, and they were allegedly being evasive about it, and there's paranoia. These shootings make people heightened with concern and fear. So it's a ripple effect. We're feeling it down here.
Yeah, it's like it is an act of terrorism, and it's every parent and child's worst nightmare. And for these young kids to go through this, I remember when I covered the Newtown shootings as a reporter, and I had to go up there, and I went to the schoolhouse where they gathered all of the parents to meet their children. Same thing happened here. They had them report, I think, to a hotel, and their parents there, they're waiting with their hearts in their stomachs for the children to trickle in to see if their child is alive. And in the Newtown situation, they had to call a couple of parents into a separate room. Those were the parents whose children did not make it. Their children never walked through the door. They had to go in that room to be notified and identify pictures of their children. It's just such a gut-wrenching experience all around, from the moment that the shooting takes place throughout that entire suspenseful time when people are being killed and they're waiting for help, up until when the parents are trying to find their children and either the children walk in or they don't. It is truly terrorism.
I agree with you, and what makes it even more frustrating is that, and no one's going to say this, but I'm not a politician so I can say it, if they're being intellectually honest, the analysis has to start with, if somebody wants to get into a school and commit harm on children, they can do it.
Yeah,
that's
we've
the
seen
analysis
different
where
ways.
you start.
Yeah.
You're not going to prevent it fully.
Well, but what about now the debate, obviously, that all the politicians are hopping on board and people have been affected by this who are saying that the gun laws just need to change. I mean, in Florida, there's two approaches, right, to that legally. You can change things by making background checks stricter, for example, when you are legally purchasing a gun. But is there ever a way to really regulate the illegal sale, the black market sale of these guns?
No, they'll be everywhere. They'll take away the guns from the good people. Look, there's no easy fix, and I see both sides. And I saw something today about a picture of the guns that were in existence, the muskets, I guess they were called, right? That could shoot 1 to 2 rounds every minute. That was when the Second Amendment came out. And then there was a gun next to it, the one that he used, the assault rifle, and that shoots like 45 rounds a minute. And so the question is, why aren't the gun laws evolving and changing to, with the technology.
Yeah, because that's a legal argument. I mean, when people defend the Second Amendment, there is an approach to it where you can say the intent of the Founding Fathers, like you said, was to be able to arm people so that they could protect themselves against corrupt government. So that if the people ever needed to stage a coup, for example, or defend their homes, that they would have the opportunity to do it. But like you said at the time, that was with a musket. And so some people would argue it was never the intent that people should have militarized weapons. And the question is the answer, because this is the common thread I keep hearing from a lot of people who want guns outlawed, is the answer to just completely outlaw these types of semi-automatic assault rifles and machine guns? Why does the average person need to have access to those weapons rather than just the military?
To be continued. We can't resolve this today, Amy.
Exactly. Okay. I think that indicates to me that you might be hungry again.
or I have to earn a living.
You're like, I'm done with this. Yeah, I know. I have kept you long, Mark. Thank you so much. I appreciate it.
Thank you, Amy. I enjoyed it.
All right. Take care. Earn a living. Come on. He just said that he's going to go on to another show to do an interview about the Florida shooting thing. All right, so let's go now. We are waiting for the hearing. Nevada versus Janet Solander. This is a foster parent who is accused of doing atrocious things to children in her care, including catheterizing them, punishing them when they urinated, making them eat their soiled underwear, beating them, assaulting them, and making them sleep naked on wooden boards. So she's facing all of these charges, and we're expecting opening statements today. We're also on verdict watch for Bob Ward, the man accused of shooting his wife. He claims that it was an accident. But for now, let's go back to those motion hearings, Nevada versus Janet Solander.